Namaskar and once again a very good evening to all. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, I extend a warm welcome to all the participants for today's lecture in this important series designed for the preparation of district judge and civil judicial magistrate first class and civil judge junior division examination. In the last two sessions, I had already given detailed introduction of our esteemed speaker. However, for the benefit of those aspirants who could not attend, I take this opportunity to briefly introduce him. Shri Sandeep Dnyanoba Munde sir is presently serving as a Deputy Registrar Group A at the Maharashtra Administrative Tribunal Mumbai bench at Aurangabad since January 2023. He secured first rank in Maharashtra through MPSC for this prestigious post. Before joining this current position from 2014 until his selection, he practiced law at the High Court of Bombay bench at Aurangabad from 2020 to 2025. He has been actively teaching subjects such as Civil Procedure Code, Administrative Law, and Jurisprudence, etc. He has also qualified for the interviews for the post of Civil Judge, Junior Division, and Assistant Public Prosecutor. I would like to invite Shri Sandeep Munde sir to deliver his third lecture on the Civil Procedure Code. Thank you, sir.
Thank you, sir. Good evening to all. So, in the last lecture, we have already discussed the provisions of the Code of Civil Procedure from Section 1 to Section 25. Thereafter, we started with the Section 26. Section 26 and Order 4 deals with regards to the institution of suit. For the institution of suit, we have what are the essential things for the institution of the suit. So, in the last lecture also I have told you, there are the four essential things for the institution of the suit. First one, that there should be the opposing parties. There must be the opposing parties. Therefore, Order 1 deals with regards to the parties to the suit. Who will be the parties to the suit? At least there should be the two parties to the suit. One should be the plaintiff, another should be the defendant. Second important thing is the subject matter in dispute. Second important thing is the subject matter in dispute. There should be the subject matter, involvement of the subject matter in dispute. Third essential thing is the cause of action. Unless and until there is the cause of action, your suit is not maintainable. And the fourth important thing is the prayers or the reliefs claim. These are the four essential ingredients or the essential things for the institution of suit or for the essentials of the suit. Now, we will see one by one as we have to draft the plaintiff. We have to see who may be joined as the parties. We have to see how to draft a cause of action, how to frame a suit, who are entitled to be represented before the court of law, who may be called as the recognized agents, why there is the requirement of the pleaders, that is the Order 3, recognized agents and the pleaders. Order 6, 7, and 8, pleadings generally, plaint, and the 8th one is the written statement, set off, and counterclaim. So, first at all, we will see one by one. The first essential thing for the institution of the suit is the opposing parties. At least there should be the two parties. So, for that purpose, we will now firstly we are touching to the first schedule of the Code of Civil Procedure, that the Order 1 that deals with regards to the parties to suit. And in the Order 1, there are total 13 sections. So, why the Order 1 is important? Order 1 deals with regards to the first rule states who may be joined as a plaintiffs. Rule 3 states who may be joined as a defendant. Order 2 and 3A, it gives the power of the court to order separate trials if the court appears that the joinder of the plaintiffs or the defendants may embarrass or delay the trial of the suit. What are the important terms involved under Order 1? In Order 1, it deals with regards to the parties to the suit, plaintiff or the defendant. It deals with regards to the addition, deletion, and substitution of parties. Addition, deletion, and substitution of parties. It also deals with regards to the joinder, misjoinder, and non-joinder of the party. So, what is the proper stage to raise the objection with regards to the misjoinder or the non-joinder of the necessary party? Necessary party, concept of the necessary party, concept of the proper party, and concept of the misjoinder of party. So, in Rule 1 and 3, Rule 1 states who may be joined as a plaintiff. All persons may be joined in one suit as a plaintiffs where any right to relief in respect of are arising out of the same act or transaction or series of acts or transaction is alleged to exist in such a persons, whether jointly, severally, or in the alternative. When any act or any right of relief has been claiming and which has been arises out of the same act or the transaction or the series of act or the transaction, so more than one person may be joined as a plaintiff. Same thing with regards to the Rule 3, who may be joined as the defendant. If it is required to claim the relief against the defendants arising out of the same act or the transaction or the series of act or the transaction, all such persons can be joined as a defendant. But during pendency of any such suit, if it is found that due to the joinder of the plaintiffs or the defendants, it will embarrass or delay the trial of the suit, then the court has a power that he may put to the plaintiff to election or order separate trials or make such other order as may be expedient. So, then the Rule 4 states court may give the judgment for or against one or more of the joint parties. It is the fact that though for the proper adjudication all parties are required, it is the option or it is the power of the court to give the judgment against one or more of the joint parties. Rule 5 states defendant need not be interested in all the relief claim. It will not be required that all the relief should be against all the defendants. Some of the defendants may not be interested in the relief claim. 6, joinder of parties liable on same contract. 7, when plaintiff in doubt from whom redress is to be sought. If there is a confusion or if he is under the doubt, against whom the relief is required to be sought. If there is the pendency of any bills from the municipal corporation or from the contractor or by the state government, he is under the doubt that against whom the relief can be sought, he may sought the relief against all such defendants who are liable and to what extent it will be determined by the court. Rule 8, which states one person may sue or defend on behalf of all in the same suit. Rule 8, we can also state it is the representative suit. Under which circumstances, where there are numerous persons, in which contingencies Rule 8 is applicable, when there are numerous persons means more than one person, it is the in numbers, and one or more of such persons may, with the permission of the court, sue or be sued or may defend such suit on behalf of or for the benefit of all persons so interested. The court may direct that one or more of such persons may sue or be sued or may be defend such suit on behalf of or for the benefit of all so interested. If any such parties are numerous in numbers, they may appoint, they may authorize any of the persons. Therefore, Rule 8, Order 1 will be called as the suit in the representative capacity. One person can represent the more than one persons in the same suit. But what are the primary conditions when the suit is being filed as a representative suit? That there should be the parties must be the numerous. There should be the same interest in the suit. that it is mandatory, it is required the permission from the court, and it is also required to give the notice to all the concerns who are interested that such and such suit is being filed on behalf of you and his permission is required. In such as contingencies, if such suit has been instituted, as per the Rule 3, any person on whose behalf or for whose benefit the suit is instituted or defended under Sub-Rule 1 may apply to the court to be made a party to the such a suit. The thing from Rule 5, Rule 4, 5 and 6 is that no part of the claim in such suit shall be abandoned under Sub-Rule 1 and no such suit shall be withdrawn under Sub-Rule 3 of Rule 1 of Order 23, and no agreement, compromise or satisfaction shall be recorded in any such suit under Rule 3 of that order unless the court has given at the plaintiff expenses notice to all persons so interested. Meaning thereby, if the suit has been filed in the representative capacity, that a single person cannot make the compromise or cannot abandon his claim, or he has been precluded from withdraw the suit unless with the expenses of the plaintiff he gives the notice to the all concerned without there being a permission from the court and without there being giving notices to all concerns, he has not permitted to do such kinds of things. 5. Any person suing or defending in any suit does not proceed with due diligence in the suit or defense, court may substitute in his place any other person having the same interest in the suit. If the person who has been authorized to conduct the proceeding is not taking care with due diligence, then the court may appoint somebody who is interested in the said thing. A decree passed in a suit under this rule shall be binding on all persons on whose behalf or for whose benefit the suit is instituted or defended, as the case may be. What it reads, once you file the suit in the representative capacity, and if it decreed or it is dismissed, whatever the decision of it is binding upon all the parties to it. 8A, power of court to permit a person or body of persons to present opinion or to take part in the proceeding. If court, in the benefit of the large, permits, court has the power to permit any person or the body of persons to present his opinion. Rule 9 is the interesting. It is deals with regards to the misjoinder and non-joinder. Misjoinder or non-joinder of parties. It reads, no suit shall be defeated by the reason of the misjoinder or non-joinder of parties. And the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. And provided that nothing in this rule shall apply to the non-joinder of necessary party. If you not join the necessary parties, your suit will be defeated by the reason of non-joinder of necessary parties. But if you have joined somebody else who has misjoined, who is not required to be joined as a party, but if you have joined that person as a party, you have misjoined, your suit is not liable for defeated. But the thing, if you have non-joinder of the necessary parties, your suit will be liable for the defeated. Rule 10, suit in the name of wrong plaintiff. It is the theme under Order 1 Rule 10 with regards to the filing of the intervention application. If any person, if he is the interested person, if he is affected party, and if he has not made a party plaintiff or the party defendant in the suit, by resorting to the provision of Rule 10 of Order 1, you may file the application, or if it is found to the court that if such and such a parties are necessary and such parties are not necessary, the court may strike out or add the parties. And it is the power vested with the court under sub-rule 2 of Rule 10. Court may at any stage of the proceeding. At which stage? At any stage of the proceeding, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that name of any party improperly joined, who is not required to be joined, improperly joined, whether as a plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether a plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. So, this Rule 10 gives the power to the court with regards to the joining of the proper parties to the suit at any stage of the proceeding, also power to add, also power to strike out the party. Where defendant added, plaintiff to be amended. It is the duty of the concerned plaintiff. If the defendant has been added, it is required to amend the plaint and is required to be served. 10A, power of court to request any pleader to address it. If the court is found that it is the discretion and the court may made the request to the any pleader to address the issue for the interest which is likely to be affected, and if that party is not represented by the pleader. 11, conduct of the suit, that the court may give the conduct of suit to such person it deems proper. 12, appearance of one of several plaintiffs or the defendant for others. It is not required that all the parties should be before the court. They may recognize, they may give the power to anybody to appear before the court. The last rule of the order 1 states objection as to non-joinder and misjoinder of parties. If you have an objection that these are the necessary parties or that party is not necessary party in the suit, despite the fact he has been joined as a party, at which stage you may raise the objection. Rule 13 states all objections on the ground of non-joinder or misjoinder of parties shall be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such a settlement, unless the ground of objection was subsequently arisen, and any such objection not so taken shall be deemed to have been waived. What it indicates, in last lecture I have also told you, if you want to raise the objection, it is required to be raised the objection at the earliest possible opportunity. And in all cases, prior to the framing of the issue. Prior to touching to the order 14, under the Code of Civil Procedure, for any purposes, if you have to raise the objection, such an objection is required to be taken at the earliest possible opportunity at the first instance and in any case before the framing of the issue. What is the logic behind it? If you raise the objection with regards to it and court finds fit, court may make the issue with regards to the said, or court may decide the said objection at the earliest opportunity. So this is order 1, deals with regards to the parties to the suit. If the persons are entitled to claim the reliefs which may move in the same boat, all such a persons can be joined as a plaintiffs. The persons against whom relief is required to be sought, all such a persons can be joined as a defendants. In the Rule 8 deals with regards to the representative suit. Rule 9 deals with regards to the misjoinder and non-joinder of the parties. Your suit is liable for the defeated for the non-joinder of necessary party. Why it is required to be defeated? Because unless if you are claiming the reliefs against somebody else, he should be the party to the proceeding. The court can't give the relief against such a person who is not party to the proceeding. Therefore, at the time of making the parties, you should be careful with regards to it. And on the basis of these rules, particularly with regards to the misjoinder and non-joinder, there will be the question with regards to the preliminary examination. And the last, if you want to take the objection, if you have to raise the objection with regards to the non-joinder or misjoinder of the parties, you are required to raise the objection at the earliest possible opportunity, at the first instance or at any cost, prior to the framing of the issue. So the order first deals with regards to the parties to the suit. Now we will move further with the order 2. What is the heading of order 2? Order 2 is the frame of suit. We all know what is the frame. But here we have to consider what is the frame of suit. Rule 1 states frame of suit. Every suit shall, as far as practicable, be framed so as to afford ground for final decision upon the subject in disputes and to prevent further litigation concerning them. In last lecture, while discussing bar to further suit, their third example or from the order part, order 2, rule 2 is there with regards to bar to further suit. What rule 2 states suit to include the whole claim. Every suit shall include the whole claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. You have to keep in mind what is the basic theme of the order 2 of the frame of suit is that whatever the cause of actions, whatever the reliefs which are for the plaintiff is entitled, it is the duty of the plaintiff to include the whole claim at the one time. He may not relinquish, or if he relinquish or if he omit to make any of the kinds of the such reliefs, he is not entitled thereafter to claim any kind of relief with regards to the remaining portion. If you peruse the illustration given under the Code of Civil Procedure, it deals with regards to the rent of 1200 rupees. And if he has not been claimed, the reliefs for the, he has A suits in B in 1908 only for the rent of 1906, A shall not afterwards sue B for the rent due for 1905 and 1907. Meaning thereby, if you are going to file the suit against the defendant, you may join all the cause of actions, you may claim all the reliefs against the defendant in the one suit. It is the basic theme of the order to frame of suit. Joinder of cause of actions. If there are it is arising from the same things, then it can be, all the cause of actions can be joined. For only certain claims to be joined for recovery of immovable property. If it is the suit for recovery of immovable property, only the claims regarding the means, profits or the arrears, or the claims for damages for the breach of any contract, or the claims which is relief sought is based on the same cause of action, that can be joined along with when the suit property is the immovable property. Fifth, the claims by or against the administrators or the here. 6, power of court to order separate trials. If there is it is found that the many cause of actions has been joined together, as like the earlier order, the court has a power to order the separate trial. And the last rule, same, that deals with regards to the objection as to the misjoinder. If it is the all objections on the ground of misjoinder of cause of action shall be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement. All objections are required to be raised at the earliest possible opportunity and before the settlement of the issue. So, what is the basic theme with regards to the frame of suit? That the inclusion of whole claim is must, that all matter in dispute between the parties relating to the same cause of action should be disposed of in the same suit so as to prevent the further litigation. And what is the object of this said? That the defendant should not be vexed twice for the same cause. Therefore, by joining all the cause of action, by giving or by claiming all the reliefs and in the one suit, it can be proceeded. So, this themes with regards to the order to frame of suit. Now, moving further what is the order 3? The heading of the order 3 is the recognized agents and the pleaders. It is divided in two parts. The first one is the recognized agents, and the second thing is the pleaders, who may appear before the court of law. If there is any cause of action to you, the party in person may appear before the court of law, or such a party may appoint some pleader to represent him before the court of law. That is the concept, either by the party in person or through by the pleader. So in order 3, two concepts are there. The first one is the recognized agents and second one is the pleader. Rule 1 states appearance etc. may be in person by recognized agent or by pleader. How you can appear before the court of law? It gives you may appear in person, party in person, or by through the recognized agent or by a pleader. Any person, application or act in or to any court required or authorized by law to be made or done by a party in such a court may, except where otherwise expressly provided by any law for the time being in force, be made or done by the party in person or by his recognized agent or by a pleader appearing, applying or acting as the case may be on his behalf. Provided that any such appearance shall, if the court so directs, be made by the party in person. If any party has been appeared through the recognized agent or through the pleader, court has a power to ask such a party to appear before party in person. Who may be called as the recognized agents? The persons, if he is giving the holding the power of attorney, authorizing, he may be the recognized agent. Whatever the service of process on the recognized agent is duly. Rule 4 deals with regards to the appointment of the pleader. So, what is the process for the appointment of the pleader? No pleader shall act if you are not carrying the wakalatnama of your client. You are not entitled to appear before the court of law or to argue on his behalf. For acting, for pleading, or for doing anything on behalf of your client, you should have a wakalatnama power which is given in writing by the client and which is required to be filed in the court. Only in that circumstances, any pleader can act before the court of law on behalf of the client. No pleader shall act for any person in any court unless he has been appointed for the purpose of such a person by a document in writing, signed by such a person or by his recognized agent or by some other person duly authorized by or under a power of attorney to make such appointment. And every such appointment shall be required to be filed in the court and shall the purpose of sub rule 1 be deemed to enforce until the determined with the leave of the court by writing signed by the client or the pleader as the case may be and filed in the court or until the client or pleader dies or until all proceedings in the suit are ended so far as regards the client. Meaning thereby, once you file the wakalatnama in the court of law, duly signed by the client and by the advocate, unless and until court discharges your appearance, you are entitled to appear on behalf of the client. Unless the client or the advocate died, or unless the court passes the order of discharging you, it is the duty of the concerned advocate to represent the party until the disposal of the said suit. It includes too many proceedings in it. Then there's sub-rule 5, no pleader who has been engaged for the purpose of pleading only shall be plead on behalf of any party unless he has filed in a court a memorandum of appearance signed by himself and stating the names of the parties to the suit. That is all covered under the wakalatnama. Service of process on pleader is the duly service. Agent is also power to accept the notice. So each person is not having a knowledge of law. each person cannot appear before the court of law. Therefore, Order 3 provides that any person may appear party in person or by appointing a recognized agent or by engaging the pleader, he may appear before the court of law. This is what the Order 3 recognized agents and the pleaders. In last lecture itself, we have in detail discussed the Order 4 and Section 26, which deals with regards to the institution of the suits. Now, the interesting point is that Order 4 deals with regards to the institution of suit, and Section 27 to 32 and Order 5 deals with regards to the issue and service of summons. But in the Order 4, it is stated institution of suit and suit to be commenced by the plaintiff. At present, we didn't know what it means by the plaintiff. Plaintiff has been given under Order 7. As well as in Rule 1, Sub-Rule 2, it is stated every plaintiff shall comply with the rules contained in Order 6. So, prior to moving further with the Order 5, we will directly touch to the Order 6. Order 6 states with regards to the pleadings generally. What is the Order 6? Order 6 is the pleadings generally. Rule 1. What the Rule 1 of Order 6 reads? Pleading shall mean plain or written statement. Meaning thereby, whatever the rules of the pleading, whatever the rules of Order 6 is applicable to Order 7 as well as Order 8. Why? For the reason that it states pleading shall mean plain or written statement. Pleading is not only applicable to the plain, but also it is also applicable to the written statement. So, what are the rules of the pleading? The whole object of the pleading is to bring parties to definite issues as to diminish expenses and delay and to prevent surprise at the hearing. What care is required at the time of pleading? You are required to give the entire facts, but how the facts are required to be stated, that has been given under Order 6. So, Rule 2 reads, pleadings to state material facts and not evidence. It is the first rule of the pleading that you have to state material facts and not evidence. It reads, every pleading shall contain and contain only. Every pleading shall contain and contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. It contains and contains only a statement in the concise form. What is the first requirement of the pleading? Pleading should be in the concise form. Pleading should state the facts and not the evidence. It should not what kind of facts are required? The fact stated should be the material fact. Pleading should not state the evidence, and the fact should be stated in the concise form. Every pleading shall, when necessary, be divided into the paragraphs numbered consecutively, each allegation being so far as convenient contained in the separate paragraph. So, how to draft the plaint and the written statement? Order 6 gives a details with regards to the how to make the pleading, what should be included into the pleading, what should not be included into the pleading. It is the rule that it should contain and contain only the statement in the concise form of the material facts by which the parties are relying, It shall not state the evidence, it shall not state the law, it shall contain only and only the material facts. Whatever the forms of the pleadings that has been given in the Appendix A, particulars to be given when necessary. If any incident is there on that day, such and such cause of action has been occurred, or if any incident is there, particular can be given. 6, 7, and 8, condition precedent, departure, denial of contract. If any such things are there, it is required to be mentioned in the pleading, but entire contents of the documents are not required to be stated in the pleading. Whatever the effect of it can be pleaded, and that document can be annexed with the plaint or the written statement, but entire format of that is not required to be mentioned. In the pleading part, as we know, all the details are required to be mentioned, but there is not required to be mentioned the law because there is the presumption of law. According to the Rule 13, neither party need in any pleading allege any matter of fact which the law presumes in his favor as to which the burden of proof lies. If you are going to file the suit for the partition, yes, female members or the sisters are entitled for the share. For that purpose, you are not required to mention the provisions or the judgment given by the Supreme Court in the pleading. You may just state presumption of law is already there. You have to state only and only the facts. That fact should be the material facts. Pleadings to be signed, that every pleading shall be signed by the party and his pleader. Address of service of notice, as you all are the practicing lawyers, it is required to give the address memo where the service has to be made. Address memo is required to be given. One of the important part of the pleading is the verification of pleading. If you just stated in the pleading, that pleading needs to be signed and verified by the party, and it is also required to be signed by the concerned lawyer. 15A verification of pleading in the commercial dispute. Striking out pleadings. If any pleading, if it is found that which is necessary, unnecessary, scandalous, frivolous, or vexatious, if which may tend to prejudice, embarrass, or delay the fair trial of the suit, which is otherwise an abuse of the process of the court, then the court has a power at any stage of the proceeding order to be struck out or amend any matter in the pleading. One of the most applications filed before the trial court that for the amendments of the pleading. At the amendments of pleading, at which stage the parties may file the application for the amendment of pleading. As we have already discussed, you have to include the whole claim. Whatever your dispute is required to be mentioned in the consent form by noting the material facts. But if at any stage, if it is found that some pleading which is necessary for the purpose of determining the real question in controversy between the parties, then the court may allow such application by either of the sides to amend the pleading. So it is one of the way available, but after the amendment, it has been stated that as soon as the trial has been commences, in spite of the due diligence are required to be shown, then only the court will allow the amendment. Or if the issues are framed, thereafter court will be rigid to allow the application for amendment. And failure to amend after order, if it has been amended, if the parties are required to carry out the amendment within the period specified by the court, and if such a period has not been specified, that is within a 14 days from the date of the order is required to amend the pleading. So, basically, what is the crux of the order 6 pleadings generally? The order 6 pleading generally, rules of order 6 is applicable to the plaint as well as to the written statement. The object is to that the party should not guard the surprise. All the pleadings, all the facts, all the material facts will be given by both the parties. That the basic features of the pleading, that the pleading should state the facts and not the law. Facts stated should be the material facts. The pleading should not state the evidence, and the fact should be stated in the concise form. So, well, I have stated again and again that it is required only be stated the material facts. What is meant by the material facts? That All facts upon which the plaintiff's cause of action or defendant defends depends, that will be the material facts according to the order 6. This is the crux of the order 6, that is the pleadings generally. Now moving further, it is also one of the ingredients for the institution of the suit, that suit will commences from the plaint. After presentation of the plaint, suit will commence. So, heading of the order 7 is the plaint. Particulars to be contained in the plaint. There will be the question for the preliminary examination, or the 3 things are important in the order 7. What is meant by the plaint? What are the essential ingredients which are required to be mentioned in the plaint? That is rule 1. Second thing, what is the concept of return of plaint according to the rule 10? On which ground court may return the plaint? That is on the ground of jurisdiction. And the third thing, that is the rejection of plaint. On which ground court may reject the plaint. Therefore, if we know the facts or the consequences of rule 10 and 11, return and rejection of the plaint, firstly, we need to understood the rule 1, particulars to be contained in the plaint. The plaint shall contain the following particulars. First, the name of the court which suit is brought, name, description and place of residence of the plaintiff, name, description and place of residence of defendant. If plaintiff or the defendant is minor or a person of unsound mind, statement to that effect. Now from E state the facts constituting the cause of action and when it arose. What is the essential ingredient? Fact constituting the cause of action. Cause of action column is essential, and when it arose, to determine whether it is in the limitation, whether it has been filed properly. F, the fact showing that the court has jurisdiction. Jurisdiction clause is very important. That why this court is having jurisdiction. In last lecture we have stated the property is situated, immovable property is situated here. Therefore, this court is having very well jurisdiction to entertain the suit. Statement with regards to the court has jurisdiction. G, the reliefs which the plaintiff claims. Fourth ingredient for the institution of the suit, you should mention the prayers relief sought, and where the plaintiff has allowed a setup or relinquish a portion of his claim, amount so allowed or relinquished, and I, a statement of the value of the subject matter of the suit for the purpose of the jurisdiction and of court fees so far as case admits. So, apart from the name of the court, name of the parties, it is required to be mentioned the cause of action, jurisdiction, prayers, if the statement to the effect of set off or the relinquishment, and the valuation and how much court fees is paid. These are the essential ingredients which are required to be mentioned in the plaint. If it is the case of money suit, in the money suit you have to give the definite figure with regards to the it in the figure as well as in the return. When the interest has been sought, it will be on the basis of interest claim. Rule 3 states where the suit subject matter of the suit is immovable property. To properly identification of that property, the four boundaries, name of that village, name of that area, whatever will be there is required to be mentioned with regards to the immovable property. If the suit plaintiff sues a representative capacity, he should mention all the things and also take the steps to that effect. 5, defendants' interest and liability to be shown. Why the defendants has been added and how they are, what is the interest involved and how they are liable is required to be mentioned in the plaint. In the cause of action and when it arises, you have to give the grounds of exemption from the limitation law. 7, specifically state relief to be specifically stated. What kind of relief you are sought against the defendant is required to be mentioned specifically in the plaint. Relief founded on the separate grounds. If it is on the separate grounds, it shall be stated as far as may be separately and distinctly. If grounds, as we know, we draft the grounds separately. Procedure on admitting plaint. If we comply all the rules herein before, Rule 9 states, where the court orders that the summons be served on the defendants in the manner provided in Rule 9 of Order 5. Order 5 is the issue and service of summons. It will direct the plaintiff to present as many copies of the plaint on the plain paper as the defendants within 7 days from the date of such order. If your plaint has been admitted and court issues summons to the defendants within a period of 7 days, mark that 7 days, it can be asked for the preliminary examination. If the plaint has been admitted within a period of 7 days, you are required to do the copies. Now, it will all with regards to the plaint. If something is missing, then the Rule 10 will come into the picture. 10. Return of plaint. Subject to the provisions of Rule 10A, plaint shall at any stage of the suit be returned to be presented to the court in which suits should have been instituted. If court it has been found that the court where the suit has been instituted is not having jurisdiction and some other court is having jurisdiction to that effect, then the court will ask to return the plaint and for the proper presentation at the proper court. What is the procedure on returning the plaint? On returning a plaint, the judge shall endorse thereon the date of its presentation and return, the name of the party presenting it, and the brief statement of the reasons for returning it. Plaint can be returned on the basis if it is found that the concerned court is not having jurisdiction to entertain the suit. The court is power to return the plaint. 10A gives the power to the concerned court to give the next date for the appearance, and if the court gives the date to both the parties shall appear before the concerned court, before the court where the suit has been presented. Important Rule 11, rejection of plaint. On what grounds court may reject the plaint? Rule 11 states, the plaint shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claim is undervalued, see where the claim is properly valued but the plaint is written upon the paper insufficiently stamped, where the suit appears from the statement in the plaint to be barred by any law, where it is not filed in the duplicate, where the plaintiff fails to comply the provisions of Rule 9. If your plaint does not disclose the cause of action, if it is undervalued, if it is properly valued but insufficiently stamped, when there is a statement which states that it is barred by any of the law, where it is not filed in the duplicate. One of the basic need for the order 4 is that suit is required to be filed in the duplicate, and if there is the non-compliance of Rule 9, these are the grounds for the rejection of plaint. If your and rejection of plaint includes in the definition of decree, rejection of plaint includes the rejection of decree. If the suit your plaint has been rejected, it is termed as a decree. 12. Procedure on rejecting the plaint. Where a plaint is rejected, the judge shall record an order to that effect with the reasons for such order, because it is the decree and for that purpose court is required to give the reasons. Where rejection of plaint does not preclude the presentation of the fresh plaint. In some contingencies, if the rejection of the plaint on any of the grounds herein before mentioned, because all are the technical ground, they may file the suit from presenting a fresh plaint in respect of the same cause of action. Documents relied on in the plaint. Production of document on which the plaintiff sues or relies, he has to refer the document and produce the copies of the said documents. Suits on the last negotiable instrument by making the statement, production of shop book, and this is the concept of the order 7, plaint. 3 questions or 1 question for the 10 marks, that what is the concept of plaint, What is the concept of return of plaint? What is the concept of rejection of plaint? So if you prepare for the what are the essential ingredients for the plaint, cover rule 1. If there is a no cause of action, your plaint will be liable for rejection. Grounds for the rejection of the plaint, for the return of the plaint, if it is not having proper jurisdiction, court has power to return the plaint. So under order 7, there will be the 3 questions: plaint, return of plaint, and the rejection of plaint. Now, without going to the order 5, order 8, we go behind to the order 5. What is the order 5? Section 27 to 32 and order 5 deals with regards to the issue and service of summons. I will not take into the details because these are the basic provisions under the Code of Civil Procedure. But what is the next stage after the institution of the suit? When the suit has been duly instituted. Section 27 reads, summons to the defendants. Where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and may be served in the manner prescribed on such a day not beyond 30 days from the date of institution of the suit, and this time limitation has been given from the Amendment Act of 1999. Meaning thereby, Section 27 28, the service of summons where defendant resides in another state. What is the procedure? 29, service of foreign summonses. 31, summons to the witnesses. 30 is the power to order discovery and like section 30 and 32 with regards to the discovery and inspection, and section 27, 28, 29 and 31 deals with regards to the summons, 31 with regards to the summons to the witness. What is the crux of the order 5? It is also divided in 2 parts, issue and service of summons. It is the issue of summons. When a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of summons on that defendant. Mark these 30 days. Keep in mind what is the period prescribed for the filing of the written statement. It is required to be filed within a period of 30 days from the date of service of summons. And if he appear before the court of law after presentation of the plaint and admits the claim, no summons is required to be issued. Sub-rule 2 states, a defendant to whom the summons has been issued under sub-rule 1 may appear, order 3, may appear in person or by a pleader duly instructed and able to answer all material questions relating to the suit, or C, by a pleader accompanied by some person able to answer all such questions. Order 3, by party in person, by recognized agent or by pleader. Every such summons shall be signed by the judge or such officer as he appoints and shall seal with the seal of the court. What are the contents, essential contents of the summons? Summons shall denote the name of the court, name of the parties, number of the suit, the next date of appearance, what order has been passed, whether you are defendant in the said, all these things are required to be mentioned in the summons. Copy of plaint is required to be annexed along with the summons. Court may order the defendant or the plaintiff to appear in person. If he engages the pleader, also the court has power to ask the party. No party to be ordered to appear in person if he is residing certain limits. Summons to either for the settlement of the issues. There are 2 kinds of summons. Summonses for the settlement of issues and summons for the final disposal of the suit. Summons to order defendant to produce the document relied by him. On issue of summons for final disposal, defendant to directed to produce his witnesses. And it is the first part, issue of summonses. Second part is the service of summons. How to effect the service of summons? Delivery of summons by the court by directly giving the copy of the said summons to the defendant by mode of RPAD, by mode of postal services, by mode of courier services which has been recognized by the High Court or the District Court, it can be made upon the defendant. In Rule 20, it is the if it has been defendant in such a way that he is not accepting the service, he is tackling the service, he is not duly served, then procedure when defendant refuses to accept the service or cannot be found. Then by affixing the copy on the conspicuous place, by affixing the copy on the courthouse, by affixing the copy where the subject matter is situated, it can be served. Another mode of service is the substituted mode of service. Despite all these things, if it has been not duly served, by giving the paper publication, defendant can be served by virtue of this order 5 Rule 20. So if the defendant in the prison, by serving to upon the jailer, notice of the summons can be served to the defendant. This is what the order 5 issue and service of summons. So to summarize today's lecture, firstly, we have discussed the who may be the parties to the suit. Second, the concept of frame of suit. Third, the recognized agents and the pleaders. Fourth, the institution of the suit along with the section 26. Fifth is the issue and service of summons. When the suit has been instituted, it is the duty of the court. Once the plaintiff has been admitted, then the court will issue summonses to the defendants. Order 6 deals with regards to the pleading generally. Order 7 deals with regards to the plaint. When the plaint duly presented before the court of law, it will be registered as a suit, and when the suit becomes registered, the court will issue summonses to the defendants, calling them to file the written statement in the said suit within a period of 30 days from the date of service of summons. So, we have already discussed the order 6 and 7. 6 states pleadings include the plaint or the written statement. What are the essential ingredients to be mentioned in the plaint? Plaint, written of plaint, rejection of plaint. So, the order A is the written statement, set off, and counter claim. So, after the service of summonses has been duly effected upon the defendant, it is now up to the defendant to appear and file the written statement before the court of law. What is the consequences of filing of the written statement? And if the written statement has not been filed, along with the written statement, the defendant may also file the set-off or the counter-claim in any suit. So, remaining portion we will discuss in the next lecture. Thank you.
Thank you, sir. Good evening, friends. First of all, I sincerely thank Shri Sandeep Munde sir for today's clear and helpful session on the Civil Procedure Code. His simple and exam-focused teaching is very useful for all the aspirants. I also thank all the participants for joining this third lecture with interest and enthusiasm. Sir has assured us that he will complete the entire CPC in this lecture series. The next session of this series will be held tomorrow at the same time. Thank you all. Good night and Shubharatri.
Thank you, sir.